Hello, everybody. Thank you for joining us in our webinar. Today, we're going to be talking about how the IRS operates. We're going to go over the structure and organization of the IRS and talk about big picture on how cases move through the IRS. But first, before we get to the content, I want to tell you a little bit about myself. The most important thing that you need to remember about me is that I am an expert at solving problems with the IRS, and also that I am a free resource available to you in your practice anytime you need. If you ever have a situation you run into and you're not exactly sure what you need to do or what steps you need to take or how exactly to solve your client's problem, just pick up the phone anytime, and I mean it, call me. There's never any charge for advice or for asking questions. I'm here to help. So with that, we're going to get to our content. So our topic for this webinar is going to be overall how the IRS operates, how are they divided. We're going to talk about how it's structured and organized, talk about the different roles and the different people at the IRS, and basically how cases work. So our agenda for today is we're basically going to talk about each of the different divisions of the IRS. Now, these aren't the technical divisions. Technically, the IRS has a small business division, a large business division, an international division. However, the way I like to think about the organization is I like to think about all the different functions and all the different departments within each bigger category. Okay, so there's 5 different functions of the IRS and 5 different quote-unquote departments. One is collections and compliance. The other one is assessments and audits. And then you have appeals. And then you have the criminal division. And then you have what's called the taxpayer advocate service. Now, these are the 5 different functions, 5 different sections of the IRS. They don't really do that good of a job at talking to each other, so it's important to keep in mind when you're dealing with the IRS. First question to find out is who you're dealing with and what kind of case it is, because each has different sets of rules and responsibilities. So the first department, the one that most cases deal with, most tax resolution cases have to do with the collections and compliance department of the IRS. The purpose of this division is that, as we all know, the U.S. tax system is based on what's called quote-unquote voluntary compliance. Everybody has to do their part and report their returns accurately and file on time. But of course, not everybody voluntarily complies with their requirements with respect to filing your returns and paying your taxes. So the collections and compliance department is there to coerce people who are not in compliance with either their filing or their payment obligations and get them into compliance, okay, with their filing and payment obligations. Okay, there's a series of actions that the IRS will take to collect taxes you owe if you don't voluntarily pay them or otherwise make arrangements to pay them. And collection actions will continue, or enforcement actions. Collections, I usually talk about collections, but also could be forcing you to file your returns. They summons you. Sometimes when you have unfiled returns, there's things they can do to force you into compliance, and that is part of the compliance and collections department. But most of the times what they're trying to do is to get you to pay your taxes or to make arrangements. Okay, so they will continue and you will stay in collections until your balance is paid in full or until the IRS can't legally collect it anymore. When the collection statute expires, or if an offer and compromise is submitted, or if an installment agreement is proposed, those are different scenarios where the IRS wouldn't legally be able to collect and you would be taken out of the collections department. Okay, so who works in collections? Who is our personnel? Okay, there are basically different types of agents. There's what's called ACS agents. ACS stands for Automated Collection System. These are the people who work in the IRS call centers, who deal with the quote-unquote collections department. When you call collections at the IRS, you're calling and speaking to an ACS agent. Okay, one of the features of dealing with them is that you get a different agent every time you pick up the phone and call. It's luck of the draw. When you pick up and you call on behalf of your client, okay, every time it'll be a different agent. They'll identify themselves, tell you who they are, ask who you are, ask who your client is, and then you go over the purpose of your call. One of the biggest tricks for dealing with ACS that you have to remember, that the first thing I had to learn and that I teach people in my office early and often, is that if you get somebody who sounds nasty and you don't think, you got to be able to read them in the first minute or two of the call, you don't think they're going to give you what you want, just hang up and pick up the phone, call back, and get somebody nicer on the phone. Because a lot of it is luck or they draw, and there's ways to kind of game the system to get the best possible results. Okay, then besides ACS agents, you have other agents called revenue officers. Okay, the difference between a revenue officer and an ACS agent is a revenue officer works in a field office, not in a call center. Okay, so all across the country, the IRS has offices all over the place. They call field offices. The collections personnel in the field office are known as IRS revenue officers. They would be assigned to some of the bigger cases. Now, when you're dealing with a revenue officer, the way it works is it's not like dealing with automated collections. That's when an IRS agent, a specific person, gets assigned to your taxpayer or your client or your account to bring you into compliance. So sometimes when they get big cases at the IRS, or they get a lot of money at stake, or business taxes or certain categories of cases, ACS won't handle them. They'll quote unquote send them to the field. They'll send them to the office that's closest to where the taxpayer lives. And then that's when somebody shows up and knocks on your door. It's a revenue officer. You get one agent assigned to your account from start to finish. Generally speaking, cases do get transferred and people retire or get promoted and so on and so forth. Okay. Another type of person in the collections department, another agent you can deal with is somebody called an offer examiner. These are the people who examine offers and compromise. So when you submit an IRS offer, and at the end of it, when you want to negotiate with somebody, you're going to be dealing with an offer examiner. I'm also throwing in this category the private debt collections. This is something new, that passed, I think, 3 years ago in 2017, where the IRS started authorizing, it might have been more recent than that. Well, the IRS now uses private debt collection agencies to collect on the debt. Now, the trick about the private debt collections, the one thing to remember is they can't really collect. It's kind of a weird law that the Congress passed. They gave the IRS the power to outsource their collections, but they did not give the collection agencies the power to issue levies or anything. So usually when my clients get dealt with, assigned to private debt collection agencies, I just tell them to blow them off and to ignore them because there's not really that much they can do. So in the collections department, there's 4 steps. Here's an overview of how a case would work through the collections department. There's 4 steps in the process. Step 1 is the taxpayer will post a new balance, or they'll default on an existing resolution, or they'll lose an appeal or fail to file an appeal. Okay, so you have the problem starts and originates. Okay, you owe the money. And then there's a notice status where they send you a series of letters. Okay, and then there's what's called active collections. And then you'd be in the pending resolution or the appeal stage. Those are the 4 different stages of a collection case. Most cases are handled by ACS. Truth be told, it's easy to kind of pull the wool over their eyes and to get favorable results. They're not always that good at collecting. Cases fall through the cracks. They get put on the back burner. Larger cases are sent to the field collections. However, a lot of times the cases will spend months and months and months in queue waiting for an agent. Small cases unlikely to be collected on, get sent to the private debt collection agencies. Okay, that's when they want to put you on the back burner. They'll send your case to the private debt collection agency. That's the best thing that can happen because the savvy taxpayer knows the only power that the debt collections have is that they can call you and ask you nicely to pay. If you simply just tell them to get bent, there's nothing they can do about it. There's no levies. They can't garnish your wages. And the good thing about being sent to collections is that's a guarantee that IRS automated collections isn't working the case anymore. Because automated collections can garnish your wages. They can wipe out your bank account. They can file liens. But once your file is with a debt collection agency, you're good as golden. It's the equivalent of being in non-collectible status, with the exception of the PATH Act ramifications. For those of you that don't know, the PATH Act is the Protecting Americans Against Tax Hikes Act. And in that, it authorized them to deny your passport if you have a seriously delinquent tax debt. So if your file is with a collection agency, although they're not going to be able to collect, if your passport expires, you might not be able to get it renewed. So that is one thing to keep in mind. So the first step in the collection process, of course, is posting a balance. That can be done one of three ways. Either the taxpayer files a tax return. You're supposed to file every year, but you can file it many years late. Some people file 4 or 5 at a time, and then they don't file for several years. And usually that's the beginning. That's what, causes the posting of the balance and is the start of the collection process. However, if you don't file, the IRS can file a substitute for a return. Or in fancy tax talk, we call them a Section 6020B assessment. Basically, what that says is the IRS can just file for you. If you don't want to do it, they'll just send you a bill and come get their money. Okay, now, when you get a substitute for return, they will issue what's called a notice of deficiency in the process, which is what you get in an audit process too. We'll talk about later on, and it gives you a right to fight about it in tax court. Okay, and also, if they file a substitute return, they usually take worst case scenario, set you as married filing separate, don't give you any deductions other than what's in your transcripts, and just throw all your income on the return without any expenses. And then you have the option always later of going back and filing an actual return and getting the balance corrected. You're not stuck once they file a substitute. It's not final necessarily, but it does give them a balance from which they can collect on. The third way to post a balance is at the end of an audit. They might assess you. You might have filed and paid, and then that year got assessed initially when you filed the return. Then there could be an additional assessment that comes with the results of an audit. Then after the assessment, after you post the balance, you go into notice status. Okay, now there's a number of different notices the IRS might send you. Really important ones are the 3 on the slide. Okay, there's actually only 2 letters that the IRS is required by law to send you before they can wipe out your bank account. The first letter they have to send you is called a notice and demand. And that letter basically says, here is your bill. Thank you. We received your tax return. Here is how much you owe. You have 10 days to pay. Okay, 10 days after you don't pay, then they have the right to, although they don't, there's a number of different letters they'll send you after that, but those aren't required by statute. The last letter you get, is what's called a final notice of intent to levy. They can send that out as much as 10 days after the initial demand. Sometimes revenue officers will do that to speed up the collection process. If you're dealing with ACS, there's 3 or 4 letters in between the initial notice and demand and the final notice of intent to levy, but they can skip those at any time. Final notice of intent to levy is the last letter you get. It says, hey, we're going to come take your stuff, and we really mean it. And it gives you a right to file an appeal. The appeal is called a collection due process appeal, and you can also go to tax court at the conclusion of that appeal. So because it's the final notice of intent to levy is also called a collection due process notice of intent to levy. It comes from the due process clause of the Constitution that says the government can't take your stuff without giving you notice and an opportunity for an impartial hearing. So this final notice of intent to levy gives you the opportunity for your impartial hearing before they come take your stuff. And the third important notice I want to tell you about is a notice of federal tax lien. It is unpredictable when the IRS is somewhat predictable, but it's largely unpredictable when the IRS will file a lien. They can do it anytime 10 days after notice of demand, just like the notice of intent to levy. They don't have to send any other letters. They send you a bill. 10 days later, you could have a lien filed, although it usually takes a lot longer than that. The thing about a lien filing is it also gives you a right to file a collection due process appeal, and it also gives you a right to petition the tax court. We're going to talk more about CDP appeals later when we talk about appeals. They're one of my favorite tools in dealing with the IRS, so we'll definitely get back to them. Once you get through the notice status and you get the collection due process notice of intent to levy, which gives you 30 days to file an appeal, at the end of the 30 days, then you go into active collections. Okay? Balances are considered to be in active collections if you have no resolution in place and the notice of intent to levy has been issued. Okay? What active collections means that you're at imminent risk of garnishment or levy. Okay? Your goal is to put a hold in place. There can be a formal hold, which are things that you do to legally stop collections, submit an offer in compromise, do a innocent spouse. Those are things that will toll the statute of limitations. There's also informal holds, where you just basically call and ask for more times. So, tips for dealing with collection cases. If you're pre-assessment, delay the assessment until you're ready to deal with it. Taxpayer hasn't filed, wait until you're good and ready to file the returns. If you're in notice status, a lot of times you're going to want to wait for CDP rights and consider filing the CDP. If you're in active collections, your first goal should be to get a collection hold or get out of collections. Either put a formal hold in place or an informal hold, the things on the screen. And if your client is subject to levy, if you're in what's called levy status, where their wages are being garnished or their bank account just recently got wiped out, then your goal is to get the levy released before you do anything else. So with that, brings us to our first polling question. Welcome back, everybody. The next department we're going to talk about at the IRS is the assessments and the audit department. Basically, what they do is what it sounds like, they audit returns to evaluate them to make sure that they were reported accurately, all expenses / other claims are legitimate. They evaluate the work done by tax preparers for penalties. They determine if returns are fraudulent. They assess various penalties for various tax-related offenses, foreign bank penalties, excise taxes. There's like 1,000 different things that they might assess you for. But anytime the IRS wants to issue a new balance that does not come from you self-reporting, filing your own return, then that goes through the assessment department or through the audit department at the IRS. They also do the substitute for returns. Like I said, in collections, if you don't file a return, the IRS will file one for you. Well, that's handled by the assessment department. Okay, so the personnel you'd be dealing with at the assessment department is an IRS tax compliance officer. They handle office audits and correspondence audits. So there's 3 different ways you can be audited. You can be done by mail, which is AKA a correspondence audit. It can be done where you go to the IRS and meet with the agent. That's called an office audit. Okay, those 2 types of audits are handled by a tax compliance officer. The trick about dealing with them, the thing to remember is they're on a limited budget as far as time allocated per case. They only have so much time to get through each file. So sometimes you can get good results because they're just in a rush to close the files, and you can kind of, sometimes they don't notice things if they're not looking, and they're usually just looking for a way out of a file. So you have to keep that in mind when you're dealing with a tax compliance officer, or really anybody at the IRS. They all really just want to close files, but especially TCOs. Whenever I go to an office audit, I always look for cues as soon as I sit down. Look around. They all have a cubicle or an office, and you look around and you see what's there and just try to shoot the breeze with them. Find some ammunition to talk about. You burn the clock. It's like, if you're up and your team's winning a football game and you're coaching, and the goal is burn the clock as much as you can to give them less time to do what they have to do. And you'd be surprised. That's often a winning technique. One time I went into an audit, and I talked to the lady about her dog. I saw pictures of dogs, and I told her I had a dog, and I made the whole thing up. I don't even have a dog. I haven't had one ever, and I was just telling her about my dog Fido or whatever, and we spent like 30 minutes talking about her dogs. And by the time she looked up at the clock, she had to rush through the audit, and guess what? I had some major concerns that she just didn't pick up on because she was busy talking about her dogs. So it's an important thing when you're dealing with compliance officers. There's also what's called internal revenue agents. They handle IRS field audits. That's the third type of audit. Third way to get audited is the IRS comes to you or to your accountant or your place of business or to any place really that you choose, and they come audit you on your site. Within each department, especially within the agents, there's different levels of agents. There's specialized groups. IRS agents are organized in groups. And, of course, within the personnel, even with collections and with every department, there's also group managers. Sometimes when you don't get what you want from the agent, you go to the manager. And, that's not on the slides, but that's one of the personnel in every department. Well, there's some groups that are specialized that only work fraud cases. So, even within the internal revenue agents, there are some groups that are given the smaller cases, some groups that are one called the Special Enforcement Program, that they only deal with cases where they think it's fraud. So it's not just tax compliance officer or revenue agent. Within that, there's different nuance, but on a big picture, if you're dealing with assessments, it's either dealing with a TCO or an RA. And notice I said revenue agent, and in collections, I was dealing with revenue officer. I don't know if it's just me. It's a big pet peeve at my first job. It was hammered into me not to get the two mixed up. And, you shouldn't call somebody a revenue agent. If they're a revenue officer, it's important to know the difference. One of them works in the collections department. One of them works in the audit department. So, overview of the audit process. It's, 6 steps. There's a pre-contact investigation, and then an initial contact is made, usually with a letter and an information document request. An appointment or appointments are set. And then there's, it can repeat. You go initial contact, they send you an information document request, you have an appointment, they review the information, and then they can do another information document request, another appointment, review the information, and you get in this endless loop. And eventually, they're done looking at documents. Hopefully, it's after 1 IDR. It could be after 10 IDRs and 10 appointments. And eventually, at the end of that cycle, you get what's called a proposed exam report. It's a 15-day letter. It gives you 15 days to tell them why you disagree and or request a conference with their group manager. And then after you get the proposed exam report, they issue what's called the final exam report, also known as a 30-day letter. It gives you 30 days to petition the Office of Appeals. And then after the final exam report, if you don't appeal, or if you do appeal and then the appeal is over, you get issued what's called notice of deficiency, which is called a 90-day letter. Then after that, you either go to appeals or you go to collections. Okay. So the next department at the IRS is going to be the appeals department. Okay, this is where you go if you disagree with an action taken by an IRS. Their purpose is to resolve tax controversies without litigation on a basis that is fair and impartial to both the government and the taxpayer. Okay. It usually involve some kind of disputed tax liability. Most appeals come from the assessment department, where they think you owe them money and you disagree, or you think you owe some lesser amount, or whatever the case may be. But you can also go to appeals from collections. It's not just for appealing tax liabilities. It's anytime the IRS takes any action you disagree with, you can end up in appeals, or not anytime, but most times. They have to take a certain prescribed action that triggers your right to go to appeal. It is a separate and independent from all other departments of the IRS. This is very important because you get a huge advantage when you go to an appeals conference, is that it's an ex parte proceeding. In lawyer talk, what that means in layman's talk is that only one side is present. Okay? You get to see what's in the file, and you get to argue against the file, and they don't have an opportunity to respond to you. The auditor. So a lot of times when I'm in an audit, I just try to get it closed. Send me a bill. It's okay. Make it $1 billion. I don't care. Do whatever you want. My first goal in an audit is usually to get the case closed, get them to stop auditing, because the more they audit, the more issues they might uncover. Send me a bill for $1 trillion. Whatever. I don't care. I'll just go to appeals and sort it out later when, the auditor is done and off the file. It's always really good because then the investigation's over and then you just have to prove the file wrong. If they're wrong, you should be able to win. So it shouldn't matter so much what they put in the report. The report is to identify the issues and to identify the worst case scenario in the IRS's initial position. But, you have an opportunity to win and you have the advantage because they don't get to rebut. So usually if you get them to rush and close a file and you get them to make a mistake, you don't want to tell them about it. Because if you tell them about it, that's why a lot of times when they're sending, they send these proposed audit, they give you the 15-day letter. I don't respond to that. Because if you respond and tell them why they're wrong, all you do is give them an opportunity to build a better case against you. No, thank you. That's your proposed report. No, thank you. I don't need to talk to your manager. Unless I think it's so clear I'm going to win and I have a chance at ending the case. And even with a 30-day letter, I'm not going to tell you why I disagree. I want the notice of deficiency. That's the last letter. And then I get your file, and then I get a copy of your file, and then I'll tell appeals why you were wrong. You don't tell the auditor why they're wrong. Why am I going to do their job for them? Let them build the case. Let them make their mistakes. and then you just attack it later in appeals when they don't have an opportunity to dispute it. So I digress though. So moving on with how the appeals is organized, there's different personnel at appeals. If you're there, you're either dealing with a settlement officer or you're dealing with an appeals officer. A settlement officer is not to be confused with the collections department. There was a tax settlement officer who they're offer examiners who examine offer and compromise. This is what's called a settlement officer. It's an appeals personnel who handles collection appeals. Collection due process, which we mentioned earlier, which you get if you get a collection due process notice of intent to levy, or if they file a lien, you have a right to do a collection due process appeal, which gives you an opportunity to explain why they shouldn't take your stuff. If you appeal an offer and compromise, if there's a trust fund recovery penalty, if there's jeopardy levies, or there's also something called a collection appeals program. So there's two main types of collection appeals. There's collection due process, which is CDP, and then there's collection appeals program, which is CAP, or CAP appeal. The other side of appeals are called appeals officers, and they handle the appeals from assessments. When the IRS sends a bill and you don't agree you should owe at the end of an audit, at the end of some kind of assessment, then you file an appeal, you get what's called an appeals officer. They handle both docketed and non-docketed cases. What I mean when I say docketed cases, I mean docketed in court. Remember when the IRS sends you a final audit letter, a 30-day letter, it gives you 30 days to petition appeals. If you file the appeal, then you have what's called an undocketed case. If you don't file the appeal, then they send you what's called a notice of a deficiency, which is also called a 90-day letter, and that gives you an option to petition the United States Tax Court. Now, if you file a tax court petition, the first thing they do is check to see if you've already been to appeals. If you have not been to appeals, then they send you there first. Before you have to go to court, you go to appeals to try to work out your case. If you go that way, it's called a docketed appeal. The other way is called an undocketed appeal. It's the same agents you're dealing with, the same office. It's just a difference in the case. I personally always try to do docketed appeals because it shows them you're ready to go to court, and it puts pressure on them from the top, because when there's docketed appeal, there's opposing counsel. When there's opposing counsel, he's getting pressured to settle the file. He doesn't want to go to trial. He gets, the pressure, and he puts the pressure down on them to close the case in a favorable, settled fashion. If you're not in docketed appeals, the appeals officer just wants to close the case, but they don't care so much if it's an agreed or an unagreed case. If they agree with you, they close the case, great, case closed. If they don't agree with you, it's fine too. They get to close the file either way. They don't have to, listen to somebody yell at them for not resolving the case. So I like docketed appeals because strategically, there's other procedural differences and other jurisdictional issues, but the main issue is it puts pressure on the agent to make an agreed case, to give you what you want or something reasonable. They also handle specialized exam programs and referrals. They have international department, state and gift department, so there's separate appeals officers for different types of issues. So basically the way the appeals process works, the taxpayer will request an appeal, or it gets transferred from the tax court. Remember I talked, there's two ways. There's the non-docketed way where you request an appeal, or the docketed way where you file in court and the court sends you to appeals and the case is transferred. Okay? And then, the right to appeal has to be triggered. You can't just file an appeal anyway, anytime. Has to be triggered by a specific IRS action that gives you a prescribed time to do an appeal, and you have to request the appeal within the time prescribed by law. It could be an administrative or docketed request, and then the case would get assigned to an appeals officer or a settlement officer. They'll schedule an appeals conference with you or an appointment. Then they'll review the file just before the appointment, usually in the day before, the day of the appointment. They'll review the file for the first time. And then you hold an appeals conference where you actually have the appointment. You argue your side. They explain the government's position. You could have some follow-up. There could be follow-up questions. It's not just, one shot, one appointment. And then sometime after the appeals conference, I've seen them up to a year after the appeals conference, where a decision is actually issued. The key when dealing with appeals is when you file the appeal, you don't hear from them for a long time. And then you get a letter in the mail with an appointment, and then you don't hear from them again. and then you go to the day of your appointment and nothing's happened, you have to know to take initiative. You have to know what to do with the file, because nobody's going to force you. It's not like litigation where you have depositions coming your way and motions and stuff to argue and discovery. No, you just file the appeal and then it's crickets. And if you don't do anything and you go to your appeal, then guess what? You're unprepared. You might lose. You have to know. So the first thing I do after I file an appeal, or when I know I'm going to appeals, is I file what's called a Freedom of Information Act request. I get a copy of the entire file so I know what I'm arguing about. And then you prepare. So by the time you get to the appeals conference, you have a presentation to show them. And you say, hey, this is why the examiner was wrong. This is why the collections officer was wrong. Here is where I'm going to win. And you scare them, because guess what? They haven't done anything. They just looked at the file for the very first time that morning if your appointment's in the afternoon. And you come in and you do the shock and awe presentation. You come in with binders and exhibits and you say, look, I've gone through the file. I have it for my FOIA. Here's the mistakes. And you show them. And then you basically, they'll roll over more often than not, because remember, they have pressure to agree. They want to close the cases agreed, especially if you're docketed. And they also have an incentive. They're overworked. They have too many files. They only have so many hours in a day that they can work on your file. So if you show them this big fancy presentation, then they're more likely to appeal, because it is going to take a whole lot of work if they disagree with you. So if you're appealing from exam, here's how you request it. If it's a small case is if you owe $25,000 less than $25,000 per period, that includes proposed tax and penalties. Then you can do a small case. And basically you just have to send a brief statement requesting a conference and indicating unagreed changes and the reason for the disagreement. If you owe more than $25,000 for any one period, then you have to do a formal protest, and there's like 6 or 7 things in the list that must be included on the protest. They are on the slide next to me. I'm not going to go through and read each one. You can see them in the handouts on what needs to be included. Now, to request from appeals, remember there's 2 main types. There's a collection due process hearing. You do that after the filing of a notice of lien or a notice of intent to levy. You use form 12153. You include a cover letter, a copy of the notice, power of attorney if you're doing it on behalf of somebody else. And then you'll get a letter with a time for the hearing. You have a hearing. Then the appeals will issue what's called a notice of determination. And then you have 30 days to file a tax court petition. This is the only time you can ever get to tax court from collections, is through what's called a collections due process hearing. And this, like I said, is after a notice of lien or a final notice of intent to levy. You have 30 days to request one of these hearings, and you can give them any reason you want on why they shouldn't take your stuff. Like, for example, you can submit an offer in compromise to the CDP officer. And then if they don't agree with your offer, if they deny it and you don't get what you want, well, guess what? You get to go see a judge. Or you can ask them to say, hey, you shouldn't be able to take my money because I shouldn't owe the penalties because I have reasonable cause. Or I qualify for innocent spouse relief. Or I should be put on a payment plan. Or all the different things that you can do in dealing with collections. You can do all of them at one-stop shop at a CDP hearing. And if you lose, you can go to court. That's how Wesley Snipes settled his taxes. He owed millions of dollars. He did an offer in compromise. He lost. Luckily, he did it through CDP. And he was able to file in tax court, and the judge ruled in his favor and ordered the IRS to settle with him. This is a sample request for a CDP. Now notice there's 2 types of hearings you can request on this form. One of them is called a collection due process hearing, and the other one is called an equivalent hearing. The difference between the 2 is you have 30 days to file a collection due process hearing. You have 2 years to file an equivalent hearing. The other difference is at the end of a collection due process hearing, you have a right to go to tax court. At the end of an equivalent hearing, you do not have a right to go to court. Whatever they say is final. So you can do a CDP request late, and you can ask for it to be treated as an equivalent hearing. There's a box on the form, as you can see, where you can request a CDP or you can request an appeals hearing or an equivalent hearing. I always check both boxes. Then the other way is through a collection appeals program. You do a form 9423. You can use this as a tool to prevent collections actions, any action quickly. If they say they're going to levy you, you don't have CDP rights, and you don't agree with what they're going to do, you can file a cap. You can't challenge the existence or amount of a tax liability, whereas you can in a CDP. and it gives administrative appeal for certain actions. It was initially limited to liens, levies, and seizures. Now it covers installment agreement rejections, modifications, terminations. Things you can't file a cap on is a trust fund recovery penalty, offer and compromise, a penalty appeal. The things on the list have their own appeal outside of the cap or the collection appeals request, where when you get a rejection letter, it'll include instructions on how to file the appeal. This is the cap form. Again, you can file one of these at pretty much any time they are threatening to do any of the things on the list. File a lien, issue a levy, seize your property if they reject or terminate your IA installment agreement or modify it another way. That's how you file a cap appeal. With that brings us to our next polling question. So welcome back. Then hopefully you guys all get your questions in and you got the answer right. The fourth department of the IRS we're going to talk about today is the Criminal Investigation Division. Their purpose is what it sounds like. They investigate potential criminal violations of the Internal Revenue Code and other related financial crimes. They don't only do tax fraud. That's the thing. They do tax evasion, money laundering. Sometimes they get involved in like structuring transactions to evade reporting requirements. There could be criminal Bank Secrecy Act violations. There could be wire fraud investigations. It usually starts, there's usually a tax component to every case. There's a reason the IRS is investigating rather than the FBI or the DEA, or sometimes they get on drug cases. Or sometimes it starts as a tax case and then they end up discovering these other crimes and charging you with something like money laundering or wire fraud. They might, just because you're dealing with IRS criminal investigations doesn't even necessarily mean that it's even a tax case. It could be a related financial case. It could have started from a tax audit and could be a bank fraud case referred from an IRS agent. Personnel you would be dealing with, other than group managers, of course, are called special agents. They're the ones with the gun and the badge. If somebody ever identifies himself from the IRS as a quote-unquote special agent, then they are with the Criminal Investigation Division. They are law enforcement personnel. They can make arrests, and they do carry a firearm. Their job is to build evidence that wrongdoing was intentional. They build a file. They do what's called a special agents report, and they present it to a case manager and make a recommendation to the prosecutor at the Department of Justice. They deal with the tax division at the Department of Justice. The attorneys, the special agents have offices all over. There's one here in Detroit. There's fewer special agent offices than there are field offices. There's usually like one main IRS office in every metropolitan area, and then there'll be like a whole bunch of other field offices where revenue officers and revenue agents are located. The special agents are usually in the downtown in the main office. Okay, but they work with the Department of Justice Tax Division, so the prosecutors are always coming in from Washington, D.C. Every time there's a court appointment, they fly in from Washington, D.C. to argue the case. It's funny how they do it that way, because even if your case is in Hawaii, they have to fly from D.C. to Hawaii or Alaska every time there's a court hearing. And then, if a prosecutor agrees that there's a case and they want to move forward with an indictment or a charge, then they'll continue working with the special agent. Their job is not over when the investigation's over. They also would be a witness in the trial if there is one, so they would be cooperating special agent, as they call. Here is the criminal investigation process, or the criminal process at a glance. This is not just for tax crimes. This applies to all federal crimes. Some states have different processes. There are 6 steps. There's investigations, where a special agent builds a file. They hand in their report. They submit it to the Department of Justice, what's called a special agent's report. And then if the Department of Justice agrees to move forward, then there's the charging phase. The DOJ accepts the case. They convene what's called a grand jury. And then the grand jury will make a decision on whether or not to charge you with a case. Basically what a grand jury is, they have a one-sided trial where it's just the prosecutor. You don't get to defend yourself. They put on all their evidence, and the jury decides if they think that there's enough for a conviction. If they think there's enough, then they'll issue what's called an indictment, which is where they formally charge you. And then you go into the pretrial phase, where there's discovery. You get to conduct depositions, talk to witnesses, you exchange documents. You litigate motions, pretrial motions. You try to get evidence excluded or, whatever the case might be. And then there's a trial. And then at the end of the trial, the jury makes a decision if you're guilty or not guilty. Then after that, there's a sentencing with a judge. If you're found guilty, there's a sentencing where the judge determines your level of guilt. And then from there, you go to appeals. And basically, the trick is, if you're dealing with a criminal case, you find out what stage you're in and try to end the case at that stage. Try to prevent it from moving to the next stage. If you're in the investigation phase, then you're sending letters to the special agent telling him, what kind of crap his case is, how he'll never get an indictment and start presenting your defense. Start finding favorable case law, start throwing all that at him so that when the DOJ sees, what your defense is going to be, he decides that it's not worth charging you. And then if he charges you, then guess what? You try to kill it. Or if he decides he wants to charge you, try to kill it before the grand jury is done. Or if you can't kill it and they're going to get you, then you try to negotiate a plea early in the process. Not with the special agent. They don't have any power to make a deal. Their only job is to build a file. But once you have somebody from the Department of Justice, if they got you and there's no way out of it, then try to get a deal either before the grand jury charges you or before the trial takes place. And then, you take a plea deal. And then, so whatever stage you're in, it's always your job is to stop the case. You focus on the prize. If you're dealing with a special agent, I'm not worried what the jury's going to think. I'm worried what the prosecutor's going to think. Make sure that I get to put whatever input I have, because the agent, they're going to build the strongest file they can. They're not necessarily going to include evidence that helps you. They're not going to point out the weaknesses. It's your job to point it out to them, and then the DOJ will see them. Okay, so here's kind of the overview. We kind of just talked about all this, so I will breeze through that slide. If you want more detail, it'll be in the handouts. Okay, and then the fifth and the final department of the IRS I want to talk about today is called the Taxpayer Advocate Service. Their purpose, was first formed in 1977. It's an independent organization that's within the IRS, but their job is to represent taxpayers and to help taxpayers protect their rights. So even though they work for the IRS, they're one of the good guys, so to speak. Okay? They are meant to help taxpayers resolve problems and prevent future problems. It is a very powerful tool if you know when to use them. I use them all the time. People think that just because I'm a lawyer and I know all about this stuff that I don't need to call the advocate. People sometimes think that advocates are only for the taxpayer to call themselves if they can't afford a lawyer, because some of what the advocate does and some of what I would do on the taxpayer's behalf kind of overlap. But no, that is not the case at all. I use them anytime I get a sticky situation. If the client doesn't have enough money, or if it's just going to take more time than it's worth for me to resolve something, if there's like an identity theft claim, I'll advise the client and guide them through the process of going to the advocate. Or if I get an out-of-control revenue officer that's not following the rules and they're issuing levies when they shouldn't be, or threatening to issue levies, or they don't issue a notice and they send it late and I miss my appeals chance because they didn't send the notice on time. For cases like that, anytime your rights are being violated, you call the advocate and they will help fix it. But the thing is about it, you have to be able to tell them specifically what right they're violating and why they need to get involved and put a stop to whatever is going on. So the personnel you would be dealing with at the Taxpayer Advocate's Office are people called case advocates. Okay, there's senior advocate associates and associate advocates, so there's different levels, and they work the case until the resolution. So you open a case, you deal with the case advocate, you tell them what you're hoping that they can do, and their job is to stay on the case. Each file gets assigned to an advocate, and they work it start to finish. Their duties are to assist taxpayers in resolving problems with the IRS. There's also a systemic advocacy department where their job is to identify areas where taxpayers commonly have problems, systemic problems, and then there's specific problems. When I say call the advocate, I'm not dealing with the systemic advocate. They more deal with Congress. There's a head taxpayer advocate, and they have a report every year that they issue to Congress about things the IRS should improve on. That's systemic advocacy. I'm talking about case advocacy, where you have a specific case, specific taxpayer, they need help. Their job is to help you resolve your problems. To the extent possible, they propose changes, and they identify legislative changes. How do you contact the taxpayer advocate? The formal way is to submit a Form 911. It's real easy to remember. If you have an emergency, you fill out a Form 911. You include any documents with the submission. There's at least one taxpayer advocate service office in every state. If you just type in Google or you go to the IRS, find a taxpayer advocate, you can click on your state. It'll list the offices if there's more than one. There's a phone and a fax number. You just fax in the Form 911 to your local office. Or you call your local office and you leave them a voicemail, tell them who you are, and they'll call you back. You can also do it through the national office, but then they just takes longer because you send it to the national office, then they have to route the case to the local office. I deal directly with the local office. Actually, there's a few people in my local office that I just pick up the phone. Sometimes I have an opportunity to steer my files. If I have a request, I'll call an advocate I like and say, hey, Karen, I need help with this file. You mind if I send it straight to you? And I'll send it to her, and she'll make sure it gets assigned to her, and then she'll help me. But, it's a very powerful tool, but they're limited. People get frustrated because they're slow. And also, if you don't know what to ask for, you have to know enough to know what to ask for so that they can help you. You have to be able to show them what the IRS is doing wrong. You have to know the rules, find the specific provision they're violating. What is it that's going wrong in the process? And if you can't do that, you'll get real frustrated dealing with them because they won't really help you. But if you can point to specific problems, they will help you. Toll-free number is on the screen. Call them if you need help. Here is a sample Form 911. Notice how there's limited space to explain what's wrong. I usually just include an attachment. Pretty much everything I do with the IRS, you'll notice throughout this presentation, anytime there's limited space, I always just say see attached, and I'll include a long legal memo with a statement of facts, says what the facts are, says what the issues are, and says why I'm right and they're wrong, and has a full breakdown. So that's the Taxpayer Advocate Service. With that, brings us to our third and final polling question. So thank you all for your time today. It's been a wonderful presenting to you all. Last thing I want to leave you with is I want to remind you one more time, if you guys have any questions, not only about today's topic, but about any problem you guys have with the IRS, anytime you need advice, don't know quite what to do to help one of your clients, call the number on the screen. I'm here to help. I have a whole team of attorneys here to answer your questions free of charge. I never charge for advice. The phone number again is 248-350-4000. That is a special hotline set up just for accountants who want to ask questions. You can also email me anytime. Thank you and goodbye.